Hello, I'm Jennifer Johnson, and today the Educational Programming Committee is joining you for Judicial Independence, Celebrating Our Past. Justice David Overstreet, our president, has announced this year's theme as Judicial Independence, the bulwark of our democracy, celebrate our past, defend it today. And so today, we're going to take a look at our past. The Illinois Constitution of 1970 provides this. The legislative, executive, and judicial branches are separate. No branch shall exercise powers belonging to another. Separation of powers seems like a simple concept, but we all know it can become complex in application. Defining the appropriate reach of each branch's power rests with the judiciary. We have been called upon to sort out the appropriate boundaries of the executive and legislative branches from time to time. So too have we been asked to define the scope of our own powers. This unenviable task requires restraint as well as tenacity. And the task is entrusted to the judicial branch because we are not a popularly controlled branch. As Illinois Supreme Court Justice James D. Heupel observed in his introductory remarks published in the summer 1997 Loyola University Chicago Law Journal, quote, "The insulation of judges from popular passions allows them to persist in impartial application of the laws, even when this compels a result disagreeable to public opinion." Justice Heupel's comment illustrates the importance of guarding our independence so that judicial decisions do not become mere reflections of the political whims of the day. Our judicial family is filled with brothers and sisters who have steadfastly protected our independence from incursion by the legislature and executive, and in doing so have helped to preserve this American experiment and the rule of law. Today, we're going to take a look at that history and get a glimpse of the shoulders on which we stand. We'll start with the case of In re Day. You'll see that the case was actually brought by Henry Bay, but due to a typo, the case will forever be known as In re Day. In 1897, the Illinois Supreme Court created a board of examiners. You can think of that board as the predecessor to the current Illinois Board of Admissions to the Bar. Everyone who wanted to be licensed to practice law in Illinois, regardless of legal education, had to pass the written exam provided by the Board of Examiners first. And this was a change in the way that lawyers were licensed. 2 years later, in 1899, there was a challenge to the court's ability to control admission to the bar. The Illinois legislature passed a law. That law allowed law school graduates to submit their diploma and a certificate of good moral character, and then receive their license. So in some ways, the legislature was attempting to turn back the clock and use a method that the Illinois Supreme Court had previously used to confer law licenses. Before the Board of Examiners was created, the diploma and certificate of good moral character had been used, but the attempt to create an end around that newly created Board of Examiners did not last long. Mr. Henry M. Bay presented his diploma from Kent, and he petitioned for admission to the court. The court denied his request, along with similar requests made by others, and an appeal ensued. Justice Cartwright delivered the opinion of the Illinois Supreme Court, pointing out the legislative overreach. Throughout the decision, there are reminders of the unique position that lawyers hold in society, positions of trust as officers of the court. Justice Cartwright points out that no one is entitled to a law license simply because they have undertaken a course of study. He says, "It must not be forgotten that restrictions upon the privilege of practicing law are created only in the interest of the public welfare and are neither for or against the student." When he defined the proper reach of the legislature, Justice Cartwright was careful to say that while the legislature can enact police legislation for the protection of the public against things hurtful or threatening to their safety and welfare, that they cannot prescribe or infringe upon the powers properly belonging to the courts. Today, the practice of law continues to be governed by the Illinois Supreme Court. Article 6 of the Illinois Constitution of 1970 makes this very clear, and the Illinois Supreme Court continues to use a bar examination to measure qualifications of those applying for law licensure. As for Mr. Henry M. Bay, we are unable to locate him in the database maintained by the ARDC. However, he did self-report that he was an attorney in a federal census. Whether he was actually licensed in the state of Illinois will remain a mystery. I'm going to pass the baton to Judge Janelle Christensen.
Hello, everybody. I'm talking about a Supreme Court case from 1981 called Rock versus Thompson, or as it was also called, The Day the Republicans Stole the Senate. Some of you, that was an actual headline from the Tribune from 1981. Some of you may be familiar with the facts of this case, but before I dive into the facts, we have to do a little legislative math. In 1981, there were 59 total Illinois senators. 30 were Democrats, 29 Republicans, and the majority of the Senate was 30, which means, of course, that the Democrats controlled the Senate. Now, I want you all to go back to 1981, which is why I have a picture of Ronald Reagan up. Ronald Reagan has nothing to do with this case, but I thought that Ronald Reagan in that image would draw everyone immediately back to 1981. The date we're focusing on in 1981 is February 15th, which also happens to be Martin Luther King Day. On this day, the Senate has business. They have to elect the president. Governor Thompson is the one who controls the election. There were two potential candidates. The Democratic candidate was Philip Rock, and he was the previous president of the Senate. And then the Republican candidate was David Shapiro. Historically, when electing the president, the votes were of all of the senators, not the senators present, but all of the senators. Because this was Martin Luther King Day, two Democrats were missing. And so Thompson made a big, bold, strategic move. He called the president for a vote. And when he did that, Thompson made a ruling. He made a ruling that it was the majority of those present and voting. And of course, by conducting the election on this day with missing two Democrats, the Republicans won. And when David Shapiro was sworn in, the Tribune article said that he was so flummoxed by the proceeding that he raised his left hand instead of his right hand when he was sworn in. Well, Philip J. Rock, there he is right there, fights back. And he immediately filed a petition for mandamus in front of the Supreme Court. And then mandamus asked for two things. One, it asked to reconvene the Senate to elect the president, and two, to prevent Shapiro from acting as the president. Here's the section of the Constitution that applies, and you can tell that there's nothing in there that talks about how the procedure is going to be to elect the president. And so Thompson argued that the Supreme Court had no jurisdiction to enter into the legislative thicket, and he also argued that the separation of powers doctrine prevented the court from ruling. Ultimately, the Supreme Court ruled in favor of Philip Roth, and they found that the election has to be the majority of the Senate membership, not the majority of the senators present and voting. And in making that ruling, they held, while this court cannot exercise legislative power, the judiciary has always had the right to review legislative acts in light of the Constitution. And the mere fact that political rights and questions are involved does not create immunity from judicial review. So the takeaway here is the judiciary has the independent power to construe the Constitution and determine whether its provisions have been disregarded by actions of any of the branches of government. And I'm going to end on a fun fact. We actually have the transcript from when Rock was sworn in, and he said this: "It's now my pleasant duty to appoint a committee of 6 senators to escort the governor from this chamber, and I hope to hell he never comes back." Kudos to John Lupton for finding us that little nugget. And I'm now going to turn this over to Judge Claire Quish.
Thanks, Janelle. So this last case is one of which you likely are all familiar, Jorgensen versus Blagojevich. So in 2002 and 2003, the General Assembly and Governor Blagojevich attempted to prevent judges from receiving the COLA, cost of living adjustment. Justice Jorgensen and Stuart Noodleman filed a class action lawsuit on behalf of all the judges in the state, naming the governor and the state comptroller as defendants. Justice Jorgensen was president of the Illinois Judges Association at the time. In their lawsuit, the plaintiffs argued that the governor and the General Assembly's actions violated the separation of powers and Article 4, Section 14 of the Illinois Constitution, which provides that judges shall receive salaries provided by law, which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state. The Circuit Court agreed with the plaintiffs, and the defendants appealed to the Illinois Supreme Court. The Illinois Supreme Court explained that while three branches of government enjoy equal status under the Constitution, their ability to withstand incursions from their coordinate branches differs significantly. The judicial branch is the most vulnerable, has no treasury, no power to collect or impose taxes. It commands no militia. To sustain itself financially and to implement its decision, it is dependent on the legislative and executive branches. The court explained that this presents a profound problem. As arbiters of law and guardians of individual liberties, members of the judiciary often find themselves at odds with other members in other branches of government. In fulfilling their duties, judges must frequently challenge the actions of the very governmental bodies who provide the financial and other resources they need to operate. Such challenges are unavoidable. They're an inherent part of the adjudicatory process. That their constitutional duty requires this of judges does not mean that their decisions will be well received by the other branches of government. Retribution against the courts for unpopular decisions is an ongoing threat. The court further explained that the vulnerability of the judicial branch is exacerbated because it has no true electoral constituency. Although judges are elected, they do not represent the voters in the same way that executive officers or legislators do. So lacking in its electoral constituency, judges command no popular allegiance, which renders them easy targets for those who would condemn unpopular judicial rulings. One of the principal means by which the founding fathers sought to protect the judiciary was by denying to the other branches of government the power to diminish judicial compensation, which was important in ensuring judicial independence. The court explained that what was at stake was the independence of the judiciary and the preservation of the separation of powers. The court affirmed the Circuit Court's ruling that the governor and the General Assembly's actions were unconstitutional, holding that if the executive branch possessed the authority to withhold judicial salaries in violation of the Constitution, there would be nothing to constrain it from further withholding funding of other necessary expenses incurred by the judicial branch and mandated by law. So accordingly, the court ordered the comptroller to pay judges the COLA. Our thanks to John Lupton, Executive Director of the Illinois Supreme Court Historic Preservation Commission, for all of his help with this project. We hope you enjoyed this trip down memory lane about Illinois' history of judicial independence. Please mark your calendars for our next program on December 8th, 2023 at the IJA ISBA mid-year meeting in Chicago. Thank you.